Hey. How's it going? Hope everybody's doing well. Chat's pretty lively today. I'm so excited. I did start the go live thing a little bit early because I wasn't sure how long I was going to take making my tea, so I didn't want to be late, so I did the start live thing early because I cheated, I guess. I don't know. I made it on time, though. So, as you guys may or may not be aware, there has been a recent judgment. You can see here. I have all of the dockets pulled up. I have them currently in order from 1 all the way down to 57. For anybody who wants to know how to get to this, it is the NCC courts.org/public. It doesn't use www. By the way. It uses ncbc. As well as a, you can just Google North Carolina Business Court and it will come up. It'll be called Public Access. So anybody who, my hair is going the opposite way that it usually goes in, and it's throwing me off my game. Not gonna lie. So, I'm glad to see everybody. I'm excited. I'm going to be looking at the initial stuff, like from the very beginning. If you haven't seen the prequel or the prelude, I guess, you can go and see that. It is 3 hours long. It is just 3 hours live. I definitely recommend you check out that one because that was like the initial fallout. So I definitely recommend checking the initial fallout. I see GTA and opinions is coming from the from the KJ side of things, so I can give a very brief. If you haven't seen my TLDR about Katie, I would recommend seeing that so you kind of know how she ties into Non Sequitur show. But I can give a very brief right now just for those that are just joining us. Katie worked with Kyle on a show on Non Sequitur, so the channel was called Non Sequitur, the main show was Non Sequitur, the branding was all Non Sequitur, and there was shows that went on within that branding. One of them was The Smoking Nun that she did with Kyle, where they just kind of joked around and talked about news and things like that. It was pretty cringe. See, this is what I mean. It's the wrong way. And so she worked with Kyle, and when the big fallout happened, she basically, I'm going to use the word help loosely, tried to slander Steve to lessen his credibility about what had gone on by accusing him of sexual assault or harassment or whatever. And then, because she kept changing her story, it's hard to say what she ended up landing on. She also accused him of fraud through the VA, Veterans Affairs, VA fraud, medical fraud, not like tax evasion stuff. Because you know how Steve is supposed to pay taxes on money he never received. Your guess is as good as mine. So, that's sort of where she came in and how that all started with at least the Non Sequitur show stuff. And then KJ got upset and talked to Kyle to be like, Kyle, people are coming after me because you're not around. Come save me. And he was like, Kyle said in his deposition that he lied to her. If you're interested in that deposition, that is on Red's Rhetoric's channel. I don't think it's on my channel. Let me double check. I'm pretty sure I don't have that on my channel. Let me just make sure. I don't trust myself about these things. So if you're interested in the deposition, I'm not going to read through the deposition during this set of streams because it's going to take me more than one stream to get through 57 freaking things. Not all of them are terribly long, which is, lucky me, but, Let me just double check. Yeah, if you want the... that was time ago, wasn't it? Here it is. The hearing to set aside transcript is on my channel. That's this one right here. So this isn't the depositions. The deposition is over on Red's Rhetoric's channel. So this is the motion to set aside when the judge made his... Okay, I cannot handle this. It's messing with my brain. And thank you, Intrigue Feline, for the deposition. Because that's the other one. That's the one I was about to go grab. So thank you that I do not have to be the one to go grab it. So there is also a playlist on my channel that's already set up. So if you go to my playlist, you can see all of the stuff that's been going on. So if you want to marathon some drama and some crazy, have at it. I tried to pull, for the most part, all of the ones that had somebody directly related. So if there's anybody that was doing stuff that wasn't directly related or was just commentary, it's not in that playlist. It's only things that are directly related. So, let's get into this, shall we? Now that introductions are done, make sure to like and subscribe and hit that bell and become a member if you want to support, and Patreon and Discord and emojis and Treacly Puffs in the chat. Yeah! Alright, let's get started. There's a dog playing upstairs. It sounds like he's having a grand old time. He's so cute. If you guys haven't seen Rex, he's got the big pumpkin head, and I love everything about it. Okay. Office of the Chief of Justice of the Supreme Court of the State of North Carolina Order. Stephen McCrae versus Kyle Russell Curtis, Guilford County File Number 19-CVS 8163. I almost feel like I should have this over here. Let's do that. That's better. That's much better. There we go. Oh, all the emojis. Yeah. No, Feline, I have not mentioned your blogs yet, but I will. To the Honorable John O. Craig III, one of the senior resident judges of the Superior Court, North Carolina, greetings. As Chief Justice of the Supreme Court of North Carolina, by virtue of authority vested in me by the Constitution of North Carolina, and in accordance to the law of North Carolina, rules of the Supreme Court, and specifically NCGS Paragraph 7A-45.4a, I hereby designate the above referenced case as mandatory complex business. Therefore, I hereby order the Honorable Louis A. Bledose III, Chief Business Court Judge, to assign the case to specific business court judge, who is hereby commissioned and assigned to hold such sessions of court as may be set to enter orders and attend to such in chambers matters and other business may be necessary and proper for the orderly disposition of the case until otherwise ordered. In witness thereof, I hereunto sign my name as to blah, 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 blah. So this is the first docket. Basically, no, I'm saying 3. I'm saying 3. I'm keeping it. So this is basically, this means that the case was accepted to complex business court. So Steve had to file, and then they had to look at it and see if it applied where it applied to. This was the confirmation that it is going to complex business court. All right. Number 2, assignment order. This is all the technical garbo. State of North Carolina, Guilford County, Steve McCrae, plaintiff versus Kyle Russell Curtis, defendant, the General Court of Justice, Superior Court Division, 19 CVS 8163, assignment order. This case, having been designated to the North Carolina Business Court by order of the Chief Justice of North Carolina Supreme Court, dated August 23rd, 2019. What's the date? It is April 20th, and our next hearing date is May 11th. Ooh. Ooh. Wait, are we at the start? How many streams are you planning? Okay, if you would like to know how many thumbnails I've already made, and I made them like a month and a half ago, or 2 months ago, maybe 3 months ago. August 23rd, 2019, hereby as assigned to the Honorable James L. Gale, Senior Business Court Judge, consistent with North Carolina General Statute 7A-45.4F. All proceedings in this action hereafter shall be before Judge Gale, except for motions in opposition to mandatory complex business designation, which shall be directed to the underassigned. The general rules of practice and procedure for the North Carolina Business Court shall apply to this case going forward. This, the 26th day of August, 2019. Been a long road to follow. Oh, the poor soul in chat who thinks there's anything to do with a settlement. Oh, sweetheart. You poor sweet summer child. North Carolina, Guilford, this is the complaint. So this is what, if I'm not mistaken, yes, this is what Steve would have filed. So, North Carolina, Guilford County, Steve McRae, plaintiff versus Kyle Russell Curtis, defendant, in the General Court of Justice, Superior Court Division, 19 CVS 8163, complaint. Plaintiff Stephen McRae, complaining of the acts of defendant, alleges and says, parties: 1. Plaintiff Stephen McRae is a citizen and resident of Riverside County, California. 2. Defendant Kyle Russell Curtis is a citizen and resident of Guilford County, North Carolina. Jurisdiction and avenue. 3. Jurisdiction over this matter is proper in this court pursuant to NC General Stat, paragraph 175.415 and 6. Venue is appropriate in this court pursuant North Carolina General Statute, paragraph 1 to 82. Background: plaintiff independently operates a YouTube channel commonly known as in or around December 2017. Defendant approached plaintiff via YouTube messaging about the possibility. Oh, you guys remember when YouTube had messaging? Bruh. Bruh. YouTube message about the possibility of creating and co-hosting a new online podcast for public entertainment. Plaintiff and defendant subsequently entered into a verbal business contract, the agreement to create and air podcast episodes now commonly known as the Non-Sequitur Show, the podcast. Prior to the launch of the podcast, plaintiff approached defendant to suggest expanding the business's endeavor, which to include a YouTube channel, the channel. Given defendant's interest in co-hosting Non-Sequitur on YouTube as well, plaintiff created the channel and by default served as the primary owner of the channel. The podcast and the channel are herein collectively referred to as Non-Sequitur. Under the agreement, plaintiff and defendant would appear as co-hosts on Non-Sequitur, would have equal discussion making authority regarding Non-Sequitur's operation and airing, and would equally divide any potential proceedings deriving from Non-Sequitur's financial success. On Non-Sequitur, plaintiff and defendant discuss various topics, including but not limited to current events and ongoing controversial political and philosophical issues. Oftentimes, special guests would appear on Non-Sequitur to contribute expertise and insight as to each topic's episode. That's actually a pretty good summary of what that show was. Plus debates. As primary owner, plaintiff had administrative rights which allowed him to access financial documents in the event that Non-Sequitur became financially profitable. On or around December 31st, 2017, defendant informed plaintiff that in order to establish search engine optimization and maximize the viewer traffic of Non-Sequitur's videos, plaintiff would need to release the primary ownership rights to the channel to the defendant. Relying on defendant's representation regarding the search engine optimization, plaintiff transferred primary ownership of the channel and the accompanying administrative rights to defendant. Womp, womp, womp. On January 17th, 2019, NonSequitur debuted its first video on the channel. In or around July 2018, NonSequitur began profiting significant revenue stemming from advertising payouts, merchandise sales, donations, and several other revenue streams. Shortly thereafter, plaintiff requested access to the financial statements provided to the defendant from YouTube in addition to his portion of NonSequitur's profits. Defendant asked plaintiff to patiently wait until April of 2019 so defendant could first handle NonSequitur's taxes. On April 16, 2019, plaintiff again requested his portion of NonSequitur's proceed. Defendant stated that his accountant would contact the plaintiff soon. Defendant refused to disclose the identity of said accountant, and plaintiff was never contacted. After multiple other attempts by plaintiff to collect his share of NonSequitur's proceeds, defendant informed plaintiff that his intent to retain the entirety of NonSequitur's earning from certain revenue streams and stated that the defendant alone operated the channel. On June 11th, 2019, plaintiff and defendant participated in a preliminary show, the pre-show, in anticipation of a live show which was ultimately posted by plaintiff on a separately owned YouTube channel titled The Death of the NonSequitur Show. This is the stream I went over a month or two ago, whenever that was, and that's the prequel. So if you haven't watched that, again, I recommend you do. I took very much care to go through it in 3 hours because I want people to be able to speed it up if they want to watch it faster. So that way, because if I had watched the video faster, one, I might have missed something, and I probably did. There's definitely more to discuss that's in there, but two, if I sped the video up, you guys would have a hard time speeding me up. So it's all the same speed. Whew. During the pre-show, defendant expressed his intent to change the direction of NonSequitur and strip plaintiff of his interest and rights in NonSequitur's operations moving forward. On the same day, defendant utilized his primary ownership rights to bar plaintiff from further accessing the channel in plaintiff's capacity as a NonSequitur co-host and partner of the business endeavor. Defendant conceded that he owes plaintiff half of the proceedings from NonSequitur's various streams of revenue up until plaintiff's ouster as a co-host on NonSequitur. However, defendant has refused to provide plaintiff with the same. Defendant continues to refuse plaintiff access to the financial information related to NonSequitur's profitability. First claim for relief, breach of contract. The allegations contained in the paragraphs above are incorporated by reference as if fully set forth herein. The agreement between plaintiff and defendant is an enforceable contract. The plaintiff fully performed his obligations under the agreement by appearing on NonSequitur as a co-host and managing the operations of NonSequitur. Defendant's failure to provide plaintiff with access to financial documents regarding NonSequitur and his equal share of profits serve as a violation to the terms of the agreement. Defendant's inferences with plaintiff's access to the channel in his capacity as co-host serves as a violation to the terms of the agreement. Pursuant to the terms of the agreement and defendant's public statements on the pre-show, defendant remains liable to plaintiff for half of NonSequitur's profits and the disclosure of the financial documents associated with NonSequitur's financial condition. The amount owed to plaintiff by defendant is for a sum certain in excess of $25,000. Plaintiff has fully performed his obligations under the agreement. Can we also note that this $25,000, NonSequitur is still currently making money. It is still a monetized channel. So it's still bringing in profit from previous episodes that people were on that's still coming in. So that's a thing. Also, hello, Kino. Welcome. I'm happy to see there's so many people here, and I'm so happy to see everybody. You figured you'd all be tired about this by now, but I mean, not everybody has either access to this because of the country they live in, or they don't have time to actually read it through. So I'm kind of doing this as like a little audiobook thing. Make life easier for everybody. Second claim for relief. We're going to get through to number 4 today, and then tomorrow we'll start with number 5 if I'm correct about my let me check my thumbnails real quick. All right, yeah, we're starting with number 5 tomorrow. I'm just going to be doing this every day until either the thing basically until we're done, and we'll just see how long it lasts. I'm just doing these one a day, man. Just going to pump these out. Except Monday. Because no, I'm not doing that on Mondays. That's my goal, at least. Second claim for relief. Fraud. The allegations contained in the paragraphs above are incorporated by reference as if fully set forth herein, as an inducement for plaintiff to surrender primary ownership rights of the channel to defendant. Defendant represented to plaintiff that defendant was required to obtain such rights for the purpose of establishing search engine optimization. Defendant's representation to plaintiff concerning defendant's need for primary ownership rights of the channel were false, were made with the intent to deceive plaintiff, and or were made with the intent to induce plaintiff to otherwise transfer the primary ownership rights of the channel to defendant so that defendant acquired sole administrative control of the channel. After defendant's acquisition of primary ownership rights of the channel, defendant excluded plaintiff from accessing the channel and ultimately informed plaintiff that he intended to carry on non sequitur without plaintiff. The false representation of the defendant were material and were reasonably calculated to deceive plaintiff into transferring primary ownership rights of the channel to defendant. Upon information and belief, defendant knew or should have known that plaintiff would not have transferred the primary ownership rights of the channel without the assurance of defendant that such was necessary to establish search engine optimization. So anytime you hear people say SEO for SEO reasons, SEO is search engine optimization. And that plaintiff would not have transferred primary ownership rights of the channel had it known the representation and assurances made by defendant were false or made with the intention of excluding plaintiff from the channel's operations. The false representation of the defendant were made with the intent to deceive plaintiff and with the intent for plaintiff to act upon the false representations by transferring primary ownership rights of the channel to defendant. Plaintiff was in fact deceived by the defendant's false representations that primary ownership rights of the channel were to be transferred to the defendant for the purpose of establishing search engine optimization. Plaintiff has suffered damage in amount in excess of $25,000 to be determined at trial. I need to switch. I've been drinking tea, but I think it's time to trade out. Bless. And happy 420, everybody. Third claim for relief, conversion. The allegations contained in the paragraph above are incorporated by reference if fully set forth herein. The agreement and the subsequent behavior of plaintiff and defendant memorialize the existence of a general partnership creating a fiduciary relationship between the partners pursuant to NC General Stat paragraph 59 through 36 and 37. The agreement provided that the plaintiff and defendant would equally share and distribute the profits deriving from non sequitur success. by refusing to provide plaintiff with his equal share of non sequitur's profit, defendant has inferred with and deprived plaintiff of its right of possession. Defendant, through his actions, has exerted an unauthorized assumption and exercised rights of ownership over plaintiff's funds to the exclusion of plaintiff. Defendant's conversion of plaintiff's funds have damaged plaintiff in an amount greater than $25,000. Fourth, claim for relief, breach of fiduciary duty. The allegations contained in the paragraph above are incorporated by reference as if fully set forth herein. The agreement and the subsequent behavior of plaintiff and defendant memorialize the existence of a general partnership creating a fiduciary relationship between the parties pursuant of North Carolina General Statute, paragraph 59 to 36 and 37. Defendant breached his fiduciary duty to plaintiff by converting and misappropriating plaintiff's shares of the funds for his own personal use or by otherwise depriving plaintiff of the same. Defendant breached his fiduciary duty to plaintiff by refusing to allow plaintiff to review the financial documents associated with non sequitur in violation of North Carolina General Statute, paragraph 59, 49, and North Carolina General Stat, paragraph 59 through 52. Defendant breached his fiduciary duty to plaintiff by refusing to provide plaintiff with a formal accounting of non sequitur's operations in violation of North Carolina General Statute, paragraph 59 to 52. Plaintiff has been damaged in an amount to be proven at trial as a result of defendant's breach of fiduciary duty to plaintiff. In addition, plaintiff's damages are ongoing and increasing due to defendant's continuous operations of non sequitur without plaintiff and due to defendant's continuous collection of profits, depriving from plaintiff previous contributions to non sequitur's fan base. Be blessed. Be blessed, my children. Fifth claim for release, unfair and deceptive trade practices. Da, 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 da. The allegations contained in the paragraphs above are incorporated by reference as if fully set forth herein. The defendant engaged in unfair or deceptive conduct by virtue of his fraudulent conduct with respect to plaintiff, his conversion of funds for which plaintiff was entitled, and his multiple breaches of his fiduciary duty pursuant to the existing partnership. The defendant's actions and conduct were in or affecting commerce. The defendant's unfair and deceptive conduct harmed plaintiff and pursuant North Carolina General Statute, paragraph 57 to 16. Excuse me. Plaintiff is entitled to recover. Oh no, I'm losing it. Compensatory. Is it pronounced compensatory? I don't think I'm pronouncing this right. Hold on, Google, tell me, how do I pronounce this? Compensatory. It looks like compensatory, but I trust nothing.
Compensatory.
Ah, I was correct. Compensatory. Damages in an amount exceeding $25,000 to have such damage trebled and recover attorney's fees pursuant to North Carolina General Statute paragraph 75 to 16.1. The sixth claim for relief. Quantum Merit? I don't know what this one is. What does that mean? Now I gotta look that up. God damn. What is this?
Quantum merit.
Oh, merit. A reasonable sum of money to be paid for services rendered or work done when the amount due is not stipulated in a legally enforceable contract. That's the legal noun. Now we know. The allegation contained in the paragraph above are incorporated by reference as if fully set forth herein. In the alternative, if and to the extent the agreement is found unenforceable, plaintiff pleads a claim in quantum merit. Plaintiff performed his duties as co-host and as partner to the business relationship created between himself and defendant. Plaintiff's contribution to non sequiturs publicity and financial success are valuable to defendant. At the time of performance, plaintiff reasonably expected to be paid for the value of his contribution to non sequiturs profitability. Defendant voluntarily accepted the benefit of plaintiff's contribution to non sequitur, knowing that plaintiff expected to be paid for the same. Defendant has failed and refused to pay plaintiff his equal portion of non sequitur's proceeds. Plaintiff has been damaged by defendant's failure to pay in an amount in excess of $25,000 to be determined at trial. Seventh claim for relief. Unjust enrichment. The allegations contained in the paragraph above are incorporated by reference as if fully set forth herein. We're on page 9 of 10. We're almost there, and then we get the next one. Look at us go. We're making really good time. I'm happy with how this is going so far. By acting as co-host on non sequitur and contributing to non sequitur's publicity and financial success, plaintiff conferred a benefit on defendant. Defendant accepted the benefit conferred by plaintiff. Plaintiff did not participate in the operations of non sequitur as a gratuity, but did I say that right? Gratuity? Yes, I did. But with the expectation of receiving payment for doing so as a partner to the business endeavor. Defendant has been unjustly enriched by the value of plaintiff's contribution to non sequitur's publicity and financial success by retaining the entirety of non sequitur's proceeds. Right. Plaintiff has been damaged by defendant's failure to pay in an amount excess of $25,000 to be determined at trial. Wherefore, plaintiff respectfully prays to the court: 1. Enter judgment against defendant for actual damages incurred by plaintiff in the amount of half of non sequitur's proceeds for defendant's breach of the agreement, such amount to be calculated pursuant to non sequitur financial documents held by defendant withheld from the plaintiff. 2. Award plaintiff reinstatement of primary ownership rights to the channel. 3. Award plaintiff relief in an amount in excess of $25,000 on the claim for fraud against defendant. 4. Award plaintiff compensatory and treble damages in an amount in excess of $25,000 on its claim for unfair and deceptive trade practices against defendant. In the alternative, award plaintiff relief on its claim for quantum merit against defendant. 6. Enter judgment against defendant for plaintiff's reasonable attorney fees. 7. Tax the costs and fees against defendant to the maximum extent allowed by law. And 8. Provide such other and further relief as the court deems just and proper. Respectfully submitted this the 23rd day of August 2019. 2019. Oh dang. We got one more. Notice of designation. State of North Carolina, Guilford County, Stephen McCrae, plaintiff versus Kyle Russell Curtis, defendant. You can see the stamp with the date on it. Spoilers. In the General Court of Justice, Superior Court Division 19 CVS 8163, notice of designation as mandatory complex business case. This is kind of important. So it's been accepted, right? So that was the complaint we read. This is them accepting the complaint as being what it is. Pursuant to North Carolina General Statute Paragraph 7A-45.4, Stephen McCrae, plaintiff, seeks to designate this case as mandatory complex business case. In good faith, based on the information reasonably available, plaintiff through counsel hereby certifies that this action meets the criteria for designation as a mandatory complex business case pursuant to North Carolina General Statute Paragraph 7A-45.4A. In that it involves a material issue related to disputes involving the law governing partnerships arising under Chapter 59 of the General Statute specifically. This action involves claims that the plaintiff alleging the failure to distribute profits of the partnership, breach of fiduciary duty of a partner, and failure to comply with law governing partner inspection rights. The complaint in this action was filed on August 23rd, 2019. So this notice is being filed no. I don't know how to pronounce it. I don't trust myself. I trust myself none. Zero. Not at all. Not a zip at all. Contemporaneously. Am I correct? Oh. Google. Really? I have to... Really?
Contemporaneously.
Thanks. Contemporaneously. I was kind of right, I guess. According to the robot. The complaint in this action was filed on August 23rd, 2019, so this notice is being filed contemporaneously as required by North Carolina General Statute Paragraph 7A-45.4 D3. Yay! Certificate of Service. I hereby certify that a copy of the foregoing was served via Guilford County Sheriff contemporaneously with the civil summons and complaint and addressed as follows. Kyle R. Curtis, 1532 Providence Church Road, Pleasant Garden, North Carolina 27313. This the 23rd day of August 2019. No, I'm not ignoring you guys. It's a little bit difficult for me to look at chat at the same time while I'm reading, so I just kind of catch up. But yes, happy 420, everybody. Yay! So that's the first four. This is basically the start of the court case. When we start getting into other dockets, this is why I kind of divide it this way. That's the notice of designation, the complaint, the designation and assignment order. So that's all of that going through. Now we get the motion. The next up we'll be covering the motion for entry of default, proposed order, affidavit of service, and I think we're also going to cover the certificate of service, if I'm not mistaken. Let me double check, just in case. I don't trust myself. I trust nothing. Oh no, I'm going all the way to 17 next time. Okay, so we're covering... tomorrow we'll be covering motion for entry of default, proposed order, affidavit of service, certificate of service, order, motion for entry of default judgment, proposed order 3, I guess, whatever, 12. Order, motion for entry of default judgment, proposed order, and other court filing. So we're covering all of the court. So all of the court here, and Steve's lawyer here at the time, and whoever else is involved, until Kyle, and then part 3 we get to the juicy bits. The juicy bits. All right, so thank you everybody for coming. This was the beginning. I recommend, if you want a brief summary, I would recommend checking out Intrigued Felines blog, write-up, paragraph, essay, however you want to put it. Her write-up or his write-up, I don't know their gender. Their write-up is on the Answers and Reason website. I also covered on my channel, so I definitely recommend checking those out. We've got part 1 and part 2 out for that. Check out the prequel prelude to this, which is really, I enjoy doing that. Again, it is 3 hours long, so I recommend speeding it up, but it is very useful for context and understanding kind of a little bit about the people that are involved. There's also... what else is there? There's all kinds of stuff. Go check out stuff. Have fun. Like and subscribe, share. Happy 420, everybody. I'm gonna drink some wine, and I don't know what else I'm gonna do. Probably something that I shouldn't. If I would do it, make sure you don't. Stay safe out there. Wash your damn hands. Like, subscribe, become a member. Thank you, Rez, for becoming a member. Feel free to support however you see fit. Don't forget we have merch, so I definitely recommend checking that out. And we are going to go live after this to go check out the latest order, which is titled... let me show you real quick. We're going to be going over number 57, Order on amended motion to show cause and notice of hearing. So we'll be doing that over on Steve's channel. So if you are somebody who is already caught up and knows what's going on, we're going to go over the latest over on Steve's channel. So I'll see you guys there. Have a good day. And I'll see you next time. Tomorrow, same bad time, same bad place. Bye.